Hi everyone, I am making this video because many of you are asking me questions, asking me why I am no longer present, so it is also incumbent upon me to make some clarifications. I don't want to express personal opinions or fall into the same mistake that the company made against me. I will just give you some information about the facts and what is the reality that emerges from the documents that the company itself has produced, precisely because they are official. In the same way, I want to go over what was my 10 years in Herbalife, ranging from 2012 to 2022. And in fact, at the very end of 2022, the company decided to terminate my contract unilaterally. Now let's go and see what the company writes during the termination. Obviously in Spanish, so it says, "We remain at your disposal as we conclude our business relationship, trusting in your cooperation and compliance with the obligations placed contractually by you. We regret the decision we are ultimately forced to make to preserve the integrity of our business model and the interests of our members. We wish you the best in your future endeavors and continue with a healthy and active lifestyle, I might add, so with another company's products, because I can't even come in to buy my products anymore." In this video precisely, I want to tell only the facts without defaming or accusing anyone in the company. I don't hide that I would gladly do that because of the disappointment I have accumulated, but I have always appreciated the real Herbalife and I have too much respect for the friends who are still in the company. What I am going to tell you are things I wish I had known in the early days as well, so I share them with you. I had a fairly rapid career. In 2016, so after 4 years, I had already achieved the status of president team, which, however, the MPC department did not recognize me 3 times in a row. At this point, I had to get my attorney involved, and then I was able to talk to then Vice President Europe, Andrew Trons, to explain the situation, who, to make a long story short, especially after analyzing the situation, evidently understood that I was in the right and that some kind of personal injustice was happening to me. After a few weeks, again, Andrew let me know through Carlos Bastos that they had made a mistake and that they would give me the qualification and ask me politely to avoid a legal dispute with the company, and following precisely, they gave me the president team qualification. Naively and in good faith, I waived the litigation. I did not give the proper importance to the communications they sent me then. And above all, I could not imagine that they would then use those materials again to strengthen their position in 2022. In fact, let's go and see what Herbalife writes in court. In the meantime, Mr. Farace continued his commissioning activities, achieving impressive economic results. After the first attempts from October 2016 to March 2017 were unsuccessful, in November 2017, he finally obtained the qualification of the president teams. Here they want to mean as if he had managed to cheat, to accomplish something wrong, and therefore I managed to obtain the qualification of president team, thereby increasing the economic benefits obtained from the component consisting of bonus royalties on the purchase of products made. Personally, it is in favor of the respective customers from the appointees entered in their own online date, as if it was something criminal that I was able to achieve. Then I want to say that as a result of these events, I also discovered important things, and I have evidence and employees who are ready to testify in the future, but in the right venues, this is not the place. After these events then, in 2016 to 2017, I continued my activity with commitment and dedication, devoting time, money, travel, countless meetings, and I was part of several operational and support teams of the company and to the support of the distributors. And so I was spending several hours a week on Zooms, both in Italy and the European Committee. I then achieved the 15K and 20K qualification in 2020, with many other qualifications also in my online date and resulting in a significant increase in volume. All qualifications were meticulously checked and analyzed in all details in 2021, and you all know how it works in these cases and consequently recognized. Also, I won 3 times the Mark Hughes bonus, and I was second for royalties in Italy. And I also did 1 month as first. So 1 month I did as first for royalties in Italy. In January 2002, I got an online training organized by the same MPC department on how to properly conduct online business, receiving a lot of appreciation from the distributors, from the Italian leaders, and also appreciation from the MPC management. And here you can see a screen of the private messages exchanged with Fernanda, thanking me and expressing appreciation for what we had done. Now we come to what happened in 2002. In June of 2002, the Vice President Europe, Andrew Trons, left the company. You remember I told you earlier that he was the person who realized that something had been committed that was not correct against me in 2016. So off he goes. And coincidentally, those executives who, after my qualification as president in 2017, had suddenly strangely disappeared, because in fact for years, no Zoom or in live event, and they are just as suddenly back present in the company and at events, in contact with distributors in some important positions within the MPC company. Also coincidentally, right around that time, they start investigations against me and my organization. But what is all this due to? Was it in qualification? No. Was it growing out of proportion? No. In fact, in all of 2002, I had a stable or even declining volume compared to the past. I went from almost 25, 26 ICAPA in royalties, and in 2001 to 15, 16, 17 in 2002. So surveys conducted right in a period of decreasing and without any qualification. This had not indisputed me, since I always accosted the controls with an extreme sense of cooperation. In November 2222, I received notice that I am at the head of a complex system of manipulation involving my entire organization. I will shortly show you what the company alleges. Basically, the allegations that they have made against a good portion of the members of my organization are having customers in common, access from devices in common, and a consistent volume scheme to receive royalties. So let's talk, for example, as if we were doing 2,500 volume points a month. So let us now analyze things in detail. Common customers. Within my organization of distributors had customers in common. However, it was not stated in the quantity, nor especially the timing. And working online, with online advertising, it's quite normal that if today a customer asks me for products, maybe then he doesn't want to use them for a few months. Later on, maybe in 3, 4, 5, 6 months, he finds another distributor's advertising and he wants to start again. It could be my distributor or someone else's distributor. I would like to make it clear, though, that no one has ever sold customers to anyone else. I repeat it in public that no one has ever given away customers to others. There is no manipulation. It would be like saying that today a customer buys in a nutrition club, a model among which business model is very much advocated by the company, and in a few months walking around he buys another smoothie in another nutrition club. Who forbids him to do so? No one, because the customer is not part of the marketing plan. I clearly asked for evidence of this to assess the impact of these hypothetical joint customers, but I never got an answer. Only in court did Herbalife release some numbers, claiming that, now let's go look at what Herbalife writes in court. 4,163 orders traceable to all of the appointees involved. Then all of the appointees involved had been sent to common recurring residential addresses in 8 different countries, demonstrating that the various appointees were sharing customer data with each other, dividing up the relevant orders, again in violation of the rules. This is what Herbalife says. It would seem like a very high number, 4,000 customers in common, but in these years, my organization has created and satisfied more than 450,000 customers. I repeat, 450,000 customers, so we are talking about a 0.9% incidence. That is to say that it is a violation if in any method of operation by which a distributor does business made 100 customers in one organization, one bought from 2 different distributors in the same organization in a time of top years. That is to say, it does not even say if in the same year, in the same month, after 10 years, it does not say. I imagine if this analysis was done on all organizations, what do you think would come out? I leave the interpretations to you, and so I am not giving some interpretations, but I am exclusively telling facts and numbers. Second charge, let's go and see what the second charge is. Your Herbalife nutrition code was used to access and place orders on my Herbalife from the same device used by other distributors and your organization. Accesses from shared devices, so that's another one of the allegations, that there have been accesses to the systems using shared devices. However, you don't know clearly who, when, what codes would have used the shared devices, what other codes. In short, it's all always very general. You don't even know how many times, how many volumes, you don't know. Again, I have asked several times for evidence, real numbers, so that I can evaluate on a case-by-case basis, and especially to prove that there is no anomaly. Also because, as expressed written in the myherbalife.com, the company writes in the privacy policy that Herbalife does not acquire the uniqueness of the devices, but these are technical details. Let's put a point on this here. So none of my requests to have the details have been answered. I have always tried to be cooperative. I have never been given the opportunity to reply or have a confrontation. In fact, on the multiple calls I have made with MPC Italy, I have received the answer, we are not dealing with it. It is all being done by EMEA. We are just passing the buck. Now we see another important point, recruitment of family and friends. This writes Herbalife, an example that might indicate a distributor's involvement in practices of manipulating the marketing plan, includes situations where new distributors are brought into the organization who are connected by family or other relationships, e.g., parents, sisters, but without actually running or developing the business. So it is saying that the serious thing is that you are recruiting your relatives, friends, and assuming that they are not running the business, because these people have never been called or heard from. Yet, as the company stated in court, numerous appointees were registered on Herbalife systems with the same residential address. Does this seem strange to you, that maybe 2 people, 3 people who code in your organization have the same residential address? It seems normal to me because anyway, maybe one does the code father, mother, daughter, maybe even those who are simply customers. But let's go to the next point though. So it's hard for me to believe that they accused me of that as well. So the prosecution claims that in a strange way I recruited mostly relatives and friends as if it was a crime. In fact, I know that's the first rule to say to talk to family, that the first customers and distributors should be people you know, or am I wrong? He claims that some of them don't personally develop the business, but none of them, as mentioned before, ever reached out with a call or a request for comparison. If I have found a way to be able to build a nice and relative business, it is precisely with relatives and friends that I share it. I think of it this way. Let's go to the next point. A consistent volume scheme to receive royalties. Here is what they write. The history of orders placed in the name of the plaintiff, that would be me, showed an unusual and suspicious pattern, keeping almost constant the threshold of 2,500 volume points per month, sufficient to qualify for receiving the maximum percentage of royalties. So the prosecution alleges that I systematically made only 2,500 volume points per month to take the maximum between royalties and bonuses. Incidentally, this is not true, and I also proved with evidence that my volume, the average, was 3,300 points, an average. I also avoid comments though. Let's see, among others, even especially President Team, how many are those who make more than 2,501? I'm just keeping to the facts though. So let's go now to the legal proceedings part. I have filed against Herbalife an emergency interlocutory appeal to be able to get the code reactivated. In addition, I had a university professor, one of the leading experts in economics in the field of network marketing in Italy, carry out an expert opinion precisely to bring out the particularity of this business and to bring out the entrepreneurial nature of this business, which is what we were always told from the stage: become your own entrepreneur, burn the ships, rely on the Herbalife business to create your own independence, your own entrepreneurial business, and also to have the value of my business network that I built in 10 years calculated. Just a few days ago, the ruling came out where it turned out that the panel of judges rejected my claim mainly because of the little protection we have with the contract we signed. Now let me explain myself better. The interesting thing is that the various hearings and confrontations with the company's lawyers revealed a lot of information that I was not aware of, and for that I also inform you, related to the Herbalife distribution contract. First point, you can't make a case for Herbalife. Here is what it says. Kind Court, this is written by Herbalife. Kind Court seized and incompetent to adjudicate on the merits by virtue of the arbitration clause contained in paragraph 4 of the general conditions of the application for appointment specifically approved by the plaintiff, which refers jurisdiction to the National and International Arbitration Chamber in Rome. So in the distribution contract, we signed a clause obligating us to arbitration, and therefore we cannot sue Herbalife without having this arbitration, which is a very expensive out-of-court procedure. We are talking about over 20,000–30,000 euros, which can take a very long time. Obviously, in this time where you are trying to enforce your rights, your network has already crumbled completely because we know what our business is like. Herbalife argues that ours is not an entrepreneurial activity, but a mere activity of collecting orders as sales representatives. Now let's read what he writes. On the groundlessness of the interlocutory application for the absence of the fumus bonus fioris, then maybe I would also have some counsel explain it to you. The non-entrepreneurial nature of the relationship of sales representative is the legitimacy of the invoked termination on the merits, as the suggested reconstruction of the facts of the case made by the other party moves evidences from an incorrect assumption of point of law. This concerns the hazardous equation between the qualification, peacefully and knowingly assumed by the plaintiff, of sales appointee and the performance of entrepreneurial activity. As is well known, the home sales appointee is one who, with or without subordination, directly or indirectly promotes the collection of purchase orders from private consumers for accounts and enterprises engaged in the sale of products or services. By express regulatory provision, the appointee lends his energies on a self-employed basis, where the relationship does not take the form of subordinate and occasional employment, in favor of a company which alone markets the products that the appointee is empowered to promote. His service in no way can itself constitute an activity of an entrepreneurial nature, and in fact, Mr. Farace, like any appointee included in the Herbalife organization, is not burdened with any economic risk. For example, in the event of missed sales, having never assumed an obligation to promote the products, and never having been required to invest money or support spent for the purpose of their marketing. He was completely devoid of any entrepreneurial organization, even minimal, which on closer inspection, not even alloyed with having set up, enjoyed the favorable tax regime proper to the activity carried out, introduced by the legislator precipitously because of the non-professional nature of the sales appointee's contribution. And yet, having said that, even today, there are official and corporate videos that say, build your own business activity. So what is this? Is this something that is not true? Maybe it would be a case of taking those videos down and saying, promote the business as an order picker. Another point, that the network is not owned by the distributor. Finally, we read, the claim that it is Herbalife itself that recognizes the sales network as a legal asset of the DIV is deliberately absolutely false. DIV would be the distributor, the focal point, a focal node of the organization, which can be transferred by him to other entities, so beneficiaries of the income generated. The only reading of the rule of conduct, 2.2, cited by the appellant himself, that would be me, would be enough to disprove it. As already noted, sales representatives in the Herbalife system do not own any network, which they cannot in any way transfer to other appointees, nor do they acquire from the sales produced by it any kind of annuity rights. That regulated by Rule 2.2 is other than a transfer of the contract. It is not a transfer of the network, thus a transfer of the contract to which does not follow the acquisition of the right to the status and benefits achieved by the transferor in case in the head of the distributor, that is, the latter does not in itself meet the requirements for the recognition of the said status and benefit. So the distributor cannot assign the network, and so they are also saying, Desumo, that it is not a given that it is inheritable, as we have always been told, because it is all at Herbalife's discretion. It cannot be assigned and it cannot be bequeathed because Herbalife has to choose or decide. The distributor is an order taker. He has no rights over his own Herbalife network. But let's go look at this recent article in the monthly newspaper Economy, where the CEO, no, she is not CEO, she is country manager of Italy, Rebecca Baroli Piazza, says in the middle here, our direct sales model based on network marketing allows each independent distributor and distributor to create their own network to work together with. Perhaps this is not true. So it would be a good idea to remove this article and continue to promote how to create your own network, since it is not yours, which is Herbalife's. Let's go to another point, going back to the earlier point. So anyone who has a code, either as a distributor or a customer, is not from your sales network, but is from Herbalife, which grants you a right to take percentages. So, obligation of exclusivity. Let's go to this other point. The fact that I was saying you have obligated me for years to be able to do only Herbalife without being able to do another business, right? Lamenting the setting up to his detriment of an exclusivity bond that for over 10 years bound him to Herbalife, page 46, as moreover pointed out by the plaintiff himself, the commitment not to try products and services associated with other direct selling companies was undertaken by the plaintiff himself solely for the purpose of willingly joining the tap-tip bonus program in order to increase his own earnings and exclusively to competing multi-level marketing firms. Nothing would have prevented Mr. Farace, as evidence of the absence of any exclusivity constraint, from engaging in promotion to multiple companies, competing with Herbalife, foregoing advancement in the marketing plan and the associated bonuses derived from the reward program if he had deemed such a choice worthwhile. So it says here that you can do other activities as well, not other network marketing. Too bad I was fined for selling some courses in 2017. But having said that, therefore, a distributor is therefore not obliged to give exclusivity to Herbalife, but he does it of his own free will because he is greedy, because he wants to access the benefits of the TAB team, and by signing precisely this bonus request form. So, if we don't want to give the exclusivity to Herbalife, Herbalife says this: you can withdraw the signed TAB team application, and as much, I can state that anyway, more than 70% of the corporate data tabs fail to accrue the bonus, so another network could do it as well. Just don't sign that document or just withdraw it, right? So another network can also be made. Right to the bonus tab. Also, the company claims that it is not an entitlement, but it is just a bonus that the company decides to give us on its own description. So I want to add further, going back to the evidence, that the company presented on me in court, that the only evidence I want to point out did not bring any evidence. The only evidence is videos so described. This notified him on December 16th, 2002. Here you can read the termination. So they terminated me on December 16th, 2002. Reading here. But then they say, following the termination of the contractual relationship, the parties exchanged emails. So I never got to talk our emails. And in, let's go to point 37, which is the important one, where the only evidence they brought are videos, which, however, as they read, they were delivered anonymously on March 17th. And they also write it, they were delivered after my termination, so they brought something only. They didn't bring any evidence of anything they said before. But they brought these videos on March 17th, so they came to them afterwards anonymously. I really invite you to see these videos. Surely they will be shot, so you can see all of them in these videos. You can see that I devoted time to people not from my organization, explained to 4, 5, 6 distributors how with 100 and 200 euros each, they could get together and make sponsorships together to locate customers. Remember, we are talking about the lockdown period, so it was 2020 when, however, they gave me the qualifications, not in 2002, so the videos were from 2002, and that they delivered them after my termination. GrassLife, on the other hand, presented these videos claiming that they were proof that I was selling Lee, which I never did. As if a distributor like me who was earning 40,000 a month would need to earn 50, 60 euros to sell Lee from someone else who was not even from my organization. Also, these videos, I was not the main actor since they were not people from online, but it was another president who had asked me a pleasure to help him in this. And so he was another president who also had investigations by MPC. He had allegations related specifically to these videos. Allegations that had basically led him to termination like me, as confirmed by the same top management in extremis. However, he was able to get a confrontation college, which I was never able to get with the top management of MPC. And he was able to explain that it was just an activity where there was no idea of manipulation or selling. There, in fact, he did not receive any particular sanction or fine, although the interpretation of the same evidence by MPC had brought him almost one step away from being terminated. So with those videos, this person was exonerated and he did not even get a fine. Instead, those videos are the only evidence brought to court for my termination. So with those videos precisely accusing me I was terminated, and of those videos that were brought to court, while others also succeeded because of interventions of some prominent people. For example, Sharman's club founders, the COA, proved that there was nothing wrong with their intent, but they still had the goal of helping people in need. Imagine during the lockdown. Maybe I had decided this other person to help people. Maybe they used that to backfire on us. However, if you wouldn't have seen these videos, like I told you before, look for them to put them off. In my opinion, they are also a good school. Now, in fact, talking about investors, I would like to understand well what they might think if it was the knowledge of all this mess that is created by some people who are also willing to put at risk the lives of those who have dedicated their whole life at risk, and like the business of those who have dedicated their whole life of the bar. And so I also wonder, by looking at the stock, what is the success of Herbalife's stock on the stock market? I see that in the last 3 years, Herbalife's stock has lost over 86%. And maybe there is to say that the company maybe doesn't always do the right things. And so the management is not always perfect. You can make bad decisions. Now, in my case, in November of the 22, were terminated about 40 people between tabs and supervisors. But many others stayed, and for more than a year, they produced a lot of volume. We are talking in the order of 150 to 200,000 volume points a month after my termination, just a month ago. So we are talking about January 2024, on the occasion of the settlement of my litigation excuse, December 2023. During the last appointment of my litigation in court, all the other distributors in my organization were terminated, so another 50 more or less between supervision and tab. But I wonder why, after 1 year, why just on the day of the last inudience? But then another question, if I was the one manipulating everything, how come after 1 year there was still 200,000 volume points? Maybe it wasn't me manipulating. Maybe everybody was working ethically. However, leave your considerations on the reasons all. However, I want to point out that all these people who were terminated, who could be any person of you, dedicated their lives to GrassLife. Everyone was earning, who had quit their jobs, who dedicated themselves full-time, who was supporting their family with this, who had a project. And I will tell you more, even my partner, who outside my organization, who had nothing to do with me, suffered the same treatment with the same generic reasons. My only fault maybe is just being a person who always tried to help everybody. All the people in my organization who had been terminated from online were earning and sustaining themselves. And this thing, of course, can't be said by everybody in GrassLife. In fact, most are obsessed with qualifying volume, but of people who really very, very well earn, I know very few. Take another one on a tour and take a look. Maybe ask for the bank accounts of some others to see if everybody is having success. And I certainly don't have to tell you what's going on in GrassLife to close qualifying, do volume, probably very serious things than what you read is in the past. There have been several cases of Tati resident team that nevertheless received the qualification, but also with evidence that the marketing plan manipulation company, like buying products 3 for 2 purchases to the last days in foreign countries, but let's say that it's not true so much. You know very well what happens. However, shortly, once this mess is over, I will of course start a new project, and I will definitely help all the people who would like to be part of it, both those who have been tarred, have been punished, but also many other people, to create true financial freedom, what I have always tried to give and give to my from online. In fact, everyone is happy and looking forward to start a new project with me. I decided to share this information just to show everything that has happened in this year and a half. Any one of you can get an idea of things right, of things wrong. Whether too strict was right is not up to me. I left you with data, with numbers, with evidence. You can judge very well then. Or maybe take a look in your own organization. No. Maybe even knocking on the door of Herbalife company to ask for explanation of what I told you about the evidence on the validity of the contract on what Herbalife wrote. I just say in the near future, we are going to see some good things. We will talk soon is a greeting to everyone. Thank you for listening to me in these minutes.